So let's start this webinar. Well, it's more than a pleasure, it's an honor to host this webinar as part of the courses in civil litigation in a comparative perspective, in the framework of the Bachelor's in Comparative European and International Legal Studies of the University of Trento Faculty of Law. Today, we are privileged to have Rebecca Attree as our special guest. Rebecca is an accredited civil and commercial and workplace mediator and solicitor in the UK. She has honored us with a brilliant review of a book I edited last year, and I would like to share with you the cover of this book. The book is titled Le parti mediazione, strumenti e tecniche, dall'esperienza pratica alla costruzione di un metodo. The parties are the mediation table, tools and techniques from practical experience to the development of a method. The book is written in both Italian and English, and you can find it in open access at this link, at the link displayed on this slide, and that I am sharing with you through the chat. Since Rebecca is fluent in Italian, she has also been able to appreciate the Italian parts. Her review is available on the website of the Conflict Managers of Tomorrow project, a project I founded years ago and I'm currently coordinating, and that involves many professionals and scholars. And if you are interested in this project, you can find out more about this project visiting the website which is displayed on this slide and that I am sharing with you in the chat. Rebecca's review of the book offers some interesting food for thought about mediation, and this is why it is related to today's webinar. In fact, today's webinar focuses on dispute resolution mechanisms, a topic that we have treated in this course from different perspectives. Rebecca will help us to see this topic also from the UK's point of view, especially after Brexit. In particular, she will focus her lecture on mediation as a way of solving international disputes. She will provide us with an overview of the science and the art of resolving international disputes by mediation. In introducing Rebecca's insightful lecture, I would like to recall the different paths to justice that we have mentioned and explored in our course. This should place Rebecca's lecture in a broader perspective and hopefully stimulate interaction in this webinar after Rebecca's lecture and through the chat. As you know, when we talk about dispute resolution mechanisms, we refer to different types of ways of solving disputes. In other words, the dispute resolution spectrum includes a wide array of mechanisms which can be classified in various ways. First, dispute resolution mechanisms can be divided into adjudicative procedures and non-adjudicative procedures. In adjudicative procedures, as we know, a dispute between two or more disputing parties is solved by a neutral third party who is entrusted with the power to determine the merits of their dispute, the merit of their relationship, with a binding decision by adjudicating who is right and who is wrong. Conversely, in non-adjudicative procedures, the parties themselves, with or without being helped by a neutral, reach their solution to their dispute by finding an agreement. Secondly, non-adjudicative procedure can be further divided into two subcategories. The first subcategories consist of facilitative procedures. The second subcategories consist of advisory or directive procedures. Facilitative procedures are procedures where no judgment or proposal are made to the parties, whereas advisory or directive procedures are procedures where the neutral intervenes by providing the parties with his or her evaluation of the dispute, and therefore with his or her directive on how to resolve that dispute. Negotiation assisted by parties representatives, normally lawyer, and facilitative mediation are included in the first subcategory, are facilitative procedures. Whereas early neutral evaluation and directive mediation are included in the second subcategory. They are directive or advisory procedures. Third, dispute resolution mechanisms can also be classified as in-court and out-of-court procedures. In-court procedures refer only to civil litigation commenced and pending before states courts, whereas out-of-court procedures refer to all disputes that are not administered by states courts. These encompass a wide spectrum of mechanisms, from negotiation to arbitration. As we know, arbitration is a form of private justice based on an arbitration clause signed by the conflicting parties and administered by an arbitrator or an arbitral tribunal, who is a private judge. Well, given this wide variety of dispute resolution mechanisms, it is for the disputing parties to choose the mechanism that is better suited to their needs. In fact, except otherwise provided for by a given legal system, litigants can elect the dispute resolution mechanism they prefer. In any case, as we know, access to court must always be guaranteed, at least in the European judicial area, according to Article 6 of the European Convention of Human Rights and Article 47 of the European Charter of Fundamental Rights. However, as we have emphasized during this course, this right to access to court is not absolute, can be limited under certain conditions, and therefore some out-of-court dispute resolution procedures can be set forth as prerequisite to go to court. And the mandatory mediation as provided in our legal system, in the Italian legal system, is certainly a clear example of this type, is a clear example of a prerequisite to go to court. Different factors weighed on parties' litigants' choice of a certain dispute settlement mechanism. One of them is certainly the cultural factor. In this course, we have often emphasized to what extent civil procedure and dispute resolution mechanisms are deeply intertwined with historical, cultural, social, economic, and legal backgrounds. More precisely, we have highlighted that due to their legal cultural backgrounds, some legal systems, such as the Italian one, have traditionally been characterized by a court-centered view. In other words, they have traditionally seen in-court proceedings as the natural, as the most appropriate, if not the unique, mechanism to resolve disputes. Conversely, other legal systems, such as the US legal system, such as the UK legal system, have traditionally been keener to favor out-of-court settlements. Well, the litigant's choice of dispute resolution mechanisms becomes even more complex in a transnational context when disputes are cross-border. In this scenario, litigants should inevitably consider additional factors when electing the appropriate dispute resolution mechanisms. Since a cross-border dispute, as we know, presents qualified connections to a variety of legal systems, the cross-border dispute would potentially be resolved in each of these legal systems. In this case, the lawyer assumes a decisive advisory role. If in-court proceedings are elected as mechanisms of solving dispute, the cross-border dispute, litigants, namely their lawyers, must deal with some highly complex legal issues, like, for example, the jurisdictional issue, that is to answer the question of which court has jurisdiction over the case. Or litigants must deal with applicable law issue, that is to answer the questions of which law will apply to the merits of the case. These issues go hand to hand with a range of further questions, which also influence the strategic decisions of a lawyer. And such questions are how to commence and proceed the lawsuit before the court which has jurisdiction over the case, when and how to appeal a judgment rendered by the seized court, how to enforce the judgment in case that is not voluntarily complied by the judgment debtor. Well, the number and complexity of these legal issues that come with in-court proceedings, especially in case of cross-border disputes, prompt many disputants to out-of-court dispute resolution mechanisms over in-court proceedings. And one of these is arbitration. As mentioned, and as we know, arbitration is an adjudicative dispute resolution procedure, and arbitration shares this feature with in-court proceedings. However, differently from in-court litigation, arbitration is a means by which two or more conflicting parties can refer a dispute, their dispute, to a neutral decision maker, the arbitrator. And the arbitrator will render a final decision, an award. And the arbitral award will determine the merits of the dispute, will be binding on the parties, and could be challenged and reviewed or set aside on very limited grounds. In case of cross-border disputes, arbitration is often chosen because neither party wishes to subject to the opponent's home court. And this is why it's very nice to quote an aphorism which says, for international trade, transnational commercial arbitration is increasingly the only game in town. And this is a quotation from Neil Andrews in his book, The Three Paths to Justice. Thus, parties to transnational disputes often stipulate for arbitration because they hope to gain various advantages, such as neutrality of venue and decision makers, selection of expert decision makers, confidentiality, avoidance of very slow courts, procedural flexibility, and awards finality. However, other non-adjudicative mechanisms have increasingly gained more ground in domestic and transnational contexts, and they are negotiation and mediation. The rise of these two means of dispute resolution, and especially the rise of mediation, is largely attributable to the high cost and excessive length of adjudicative procedures, whether it be court litigation or arbitration. As we have highlighted during this course, mediation is radically different from arbitration and adjudication in court, because the aim of mediation is to reach a settlement and not to culminate in an imposed decision, whether award or judgment. And Rebecca will provide us with an insightful lecture on the main features of mediation, on how mediation works, and how to effectively manage a mediation table. On a different note, it should be noticed that in the transnational context, it's not uncommon, for example, for corporations, to use international arbitration in combination with other ADR mechanisms. Such a combination of techniques will be specified in a multi-tiered dispute resolution clause. This type of clauses may state that if a dispute arises between two parties to a contract, they will initially be required to negotiate a resolution. If negotiation fails, mediation will be the compulsory stage before commencing an arbitration or before commencing in-court proceedings. Well, I have mentioned that in-court procedures present various shortcomings in resolving disputes, and especially cross-border disputes. And these shortcomings go from high cost to unreasonable delays. But also, out-of-court procedures are not perfect. And this is why, as we said during our course, many scholars have shown skepticism about ADR devices, about promoting settlements by negotiation or mediation. And more precisely, their objections to settlement are the following. The parties might be significantly unequal in various ways. As a consequence, a party to settlement might not fully understand his or her position. In other words, a party to settlement might be unable to precisely and exactly assess the merits of his or her case. And as a consequence, his and her full civil entitlement might turn out to be reduced by compromise. Moreover, ADR detractors argue that settlements avoid the public searchlight at the trial upon serious wrongdoing. Those who criticize the promotion of negotiation and mediation highlight the importance of recognizing the social and economic value of civil justice secured in court. They stress the importance of acknowledging that some cases need to be adjudicated by courts. More precisely, ADR detractors stress, underline, on the one hand, that court litigation embodies many values, notably the principle of publicity and reasoned decisions. And on the other hand, those who criticize ADR argue that courts' coercive powers are indispensable in some cases. Well, in my personal opinion, but we are here to discuss this topic as well, the truth lies somewhere in the middle. On the one hand, it's undeniable that there is a close interdependency between courts and the practice of ADR. In other words, as some scholars say, ADR without the credible threat of judicial determination is the sound of one hand clapping. And I really like this quotation from Jan in Judging Civil Justice. But on the other hand, it's also undeniable that we should recognize that within a mature system of civil justice, there is place for both formal and informal processes. There is place for court adjudication and out-of-court procedures. And out-of-court procedures should not necessarily be seen being considered a second-best form of justice. Conversely, court adjudication and ADR mechanisms should be seen as complementary tools. But that being said, the issue surrounding the relationship between in-court proceeding and out-of-court procedures remains open. Should civil proceedings before the courts be considered a system only of last resort, and so to be pursued only when more proportionate techniques have failed or could never have worked? And to answer these questions means to take position about issues such as the party's duty to consider mediation before going to court, or the party's duty to participate in mediation before commencing a lawsuit. Moreover, these issues entail to take position about possible consequences, possible negative consequences of parties' non-compliance with these duties in the subsequent in-court proceedings, which will start after the failure of mediation. While these issues do not have a unique solution or answer, instead, different legal systems address these issues in different ways. And this is why we can say that the debate is ongoing. And this is why we have here Rebecca, and this is time to pass the word to our keynote speaker, because she will certainly provide us with stimulating food for thought also on these issues by outlining an overview of resolving international dispute by mediation, the science and the art. And I thank Rebecca again for her participation. And as I said, I will be here to manage the chat and to collect the questions and comments that maybe we can address when Rebecca will be finished with her presentation. Rebecca, the floor is yours.
Grazie, Silvana. Thank you so much for such an excellent and very thorough and complete introduction to this topic. I'm very excited to be here with all of you. I'm here from London. I love Italy. It is a pity I cannot be there in person with you in Italy, but I hope on future occasions I can come to speak to you in person. But for today, I'm joining you, and I'd just like to share my screen with you so that you may see my my slides. Hopefully you can now see what I'm going to talk about. And I discussed with Silvana that the title we decided to call my lecture today, Resolving International Disputes by Mediation, the Art and the Science, because I really do think it's a combination of both. There are some technical skills, but there is also a degree of creativity in flair in mediation. And I'm excited by the challenge of the quote that Silvana so well made, that the only game in town is commercial arbitration. I hope very much that by the time I finish my lecture today, you will think that perhaps mediation is becoming the only game in town. Certainly, I think it has a very important place in our methods for resolving disputes, and particularly internationally. So just as Silvana has presented me, I am a civil and commercial workplace mediator based in England, but I do a lot of mediations that are international. I'm a solicitor, and a lot of my work involves resolving disputes in relation to contracts, commercial contracts, property, aviation, wills, and I have a particular interest also in family business disputes as well. So what I'd like to run through with you in this morning's lecture are a few key points. Firstly, what is mediation? And then where does mediation sit in the spectrum of alternative dispute resolution? Silvana has already very well placed that. Just a few points from my perspective in that. Then moving on to international issues and trends, because it is so important that we see any dispute resolution method in the context of the global position. And then some words about typical process. That is changing all the time, because in the last year, all of my mediations have been done remotely using Zoom or a similar platform. But how is the typical process? How is it now? How is it likely to be? And then some words about mediation skills, because genuinely, I think that the skills of a mediator are life skills. I hope that when I finish this lecture, you may be interested to consider taking the training to becoming a mediator, because it's not only an amazing set of skills and a career, but also the skills to be able to mediate any kind of conflict or dispute is something which is useful. And I will say that as a mother of 3, they have occasionally been useful around my dining table over the last few years. So let's jump in and just have a look at what is mediation. So a number of points here. It's informal. You know, you don't have to put a robe and gown on. People will use their first names. And the idea is that this also allows for people to feel a little more relaxed than they would be in court. And from my perspective and many mediators' perspective, that is important. because people often make the best decisions when they are feeling a little more relaxed and not completely under pressure. And the point about mediation is it is for the parties to decide. As Silvana has indicated, at mediation, no one will impose an outcome on the parties in conflict. It is the party's decision. And it's also very flexible as a process. So you can set it up quickly. You can meet in a hotel. You can meet in a lawyer's office. You can even just meet like we are doing here today on Zoom. And it doesn't have to be one session. It can be a number of sessions. So for example, I recently had a mediation where two of the parties were in the United States. So we decided rather than have one 8-hour mediation, we would have an hour session with each of those first on a different day, and then the main mediation session was 6 hours, thereby straddling the time difference a little more easily. One important point about mediation is that it's voluntary. The parties voluntarily agree to mediate, usually. In England, it would be, I have never heard of a court actually ordering mediation. A court may order a stay for the parties to seek to negotiate a settlement, and within that it is implied that it could be a mediation. But fundamental to mediation is that it's voluntary. Now I am aware, and as Silvana has mentioned, that in some countries, such as Italy, there are sometimes requirements that parties do mediate before going to court. But generally, the provisions for those are in relation to smaller matters and in relation to certain types of dispute. Maybe we can discuss this more, but it's an interesting point to bear in mind. Some countries are starting to adopt this formula because they are saying, let's take the weight and the pressure off the courts. Let's encourage the parties to see if they can find a resolution, particularly for smaller matters and where it would be desirable. And in England at the moment, there is a lot of discussion about that. At the moment, it is entirely voluntary going to mediation. But for example, in the sphere of family disputes, there it is necessary that parties go to what's called a mediation information advance meeting. So they have to go to a meeting for about an hour with a mediator to be told what mediation is, and then they have to tick a box on their court form to say, I've heard all about it, and no, I don't want to, or yes, I do. So they have to get that information in the family arena in England. Really, really key to mediation is that it's confidential. That's the fact of the mediation, the fact that it's happening, and also what's happening within the mediation. If I go into one room or in a Zoom breakout room, one party tells me many things, that is confidential. And I will not disclose what is said to the other party unless that first party authorizes me to so disclose. And if they do, I will be crystal clear on exactly what it is I may disclose and how I may say it. And the fact that mediations are confidential as a whole process, unless the parties in the settlement agreement decide to waiver some of that confidentiality, that's why we don't hear much about mediation. We don't hear about the amazing success stories because it's all behind closed doors. But there are many large international disputes that are settled very successfully by mediation. The other important aspect of mediation is that it is without prejudice to any court proceedings if they happen. Many of you will be understanding already that expression, but in case it's not familiar to all of you, that means that what is said or disclosed or deduced at a mediation cannot later be brought to court. Now, there are a few small exceptions to that, but that is the basic principle. So the idea is it creates a bubble. It creates a space where people can say and show things that a court will not later see. So one of the really important things that can arise from that is an apology. We as lawyers know that an apology could be an admission of liability. And anyway, people in dispute are usually really reluctant to apologize. But in my experience in a mediation, it is quite frequent that one party will say, I'm sorry that we're in this situation. I'm sorry what happened on that day. I want to move on. And that is a really powerful tool to unlock. But the fact that that can be said confidentially, and it would never be written in any open letter between solicitors that could later be shown to court, the fact that people can say that in my mediation room and ask me to disclose it to the other is a powerful aspect of mediation, even between the top CEOs of large organizations. I'm not just talking about personal disputes there at all. And Silvana also mentioned the European Court of Human Rights and Article 6 and how mediation does not in principle affect and get in the way of people still having their rights of going to court, because fundamentally the parties decide whether to settle or not, and it is in their hands whether they decide that they want to not settle and still go to court. So when can mediation be used? Here's a picture of me just by Tower Bridge. Some of you may be familiar with that backdrop. The Tower of London is the biggest tourist attraction in London. I hope perhaps one day you will be able more easily to come to England. These are the offices I use for mediation. So here we have how can mediation be used? Well, I've mentioned already where I normally use mediation in my practice: civil and commercial disputes. So contract disputes, shareholder disputes, agency, distribution, competition law even. And then it can also be used for workplace. So this is another area, so linked to employment law, but where people are not finding their work situation desirable and they want to have some changes in practice. That can even be at the level of boards of directors. I've had schools where teachers have not been able to work together. I've had doctors, a general practitioner practice, a surgery, for example. And then there is also the area of family law, where it is actually probably mediation is the most popular in England. That is a separate discipline. It's a separate training to become a family mediator, but it is quite popular. And then in the international sphere as well. Why do I think it's important internationally? Because as Silvana has alluded to a little with the concept of arbitration crossing borders, with mediation, this truly works. If I have a mediation, yes, we will probably choose English as the language, but culturally you can blend mediation in the process to fit the culture and the communication approaches of particular countries and people where they are coming from. On a practical level, you know, I can, if everybody wants, I can go through the 24-hour clock and have a mediation run from London with people joining from New York, from Tokyo, from London, and people do not all have to be traveling to London to do that. So that's very helpful, particularly in comparison with a whole court process, which could take a number of days, and everybody would then have to be in London for that court hearing. The other time I think mediation is really useful is for multi-party, where you have several parties. I sometimes have mediations where I have 3 or 4 parties. My biggest one was nearly 30 people, 30. There it is an opportunity for everyone to come together on one day and to find a solution that works for everyone. So that's a very cost-effective approach. So if you were ever in the situation where you needed to resolve a dispute, people may say, how do you choose a mediator? Well, I would say looking carefully at your mediator is important in the same way as people would do some due diligence on an arbitrator. And one of the things to think about is what kind of style do they have? There isn't time to go into this today, but maybe another day we can consider the different styles of mediation through Europe, because each country, I think, has something to learn from the other. But fundamentally, the English style is quite divide. The mediator goes to one room and then to the other room. For example, in Germany, there is a greater propensity to keep everybody together in one room. And then we have, is the mediator facilitative? So are they there to get people to talk and to come up with their ideas? Or are they slightly more evaluative, where they may give a rather better view on what actually they think might be a way forward? That's quite controversial because the purists say a mediator should not be evaluative in any way. We can discuss this more. Some people may want a bicultural mediator, so I'm quite often appointed for Anglo-Italian disputes because I speak Italian and I've lived in Italy, and people may feel that they want someone who will understand some of the cultural issues. So, who are providing mediation? Well, for example, in the UK, we have some mediation providers. I set up Hexagon Mediation, which is a small panel of mediators. I also mediate through IPOS Mediation. Then I have my own direct website and appointment. But the point is that many people will argue over who will be the mediator. If people are already arguing about so many things and are in dispute, then to argue over the mediator is just one more thing. So it's quite common that people will go to a provider and say, please, can you suggest 3 mediators? And then the parties will choose from that. And that takes away some of the idea that one person who suggests a mediator has some affinity with them, which normally is not the case, but that is just an approach that people may feel reluctant about. So I think to speak very lightly on this slide, because Silvana has already dealt with it so well, images often speak more than 1,000 words. Why do I have a light bulb? Because the outcome in a mediation is as broad as your imagination, and people can have light bulb moments when they can suddenly think, look, why don't you sell your shares rather than buy them from the other party? Why don't we do a land swap where there is a boundary dispute? These are things that are not capable of being adduced by a court, because usually the court will just give damages or an order for specific performance or an injunction. In a mediation, the outcome is as broad as the imagination of the parties. And then time and money. It can be quick to set up and very cost effectively, especially if it's going to be done on Zoom. And that also, by the way, helps with the carbon footprint and all the environmental issues as well. So many boxes being ticked all at once. So why is ADR so important? Yeah, it saves money and it saves time. There are a few statistics on that. So how are international trends taking place as I speak? Well, mediation first of all began in Australia, and then it became more common in the US, and then it moved over here to the EU. In the US, it's very popular. But the most popular process is that the parties do not meet at all. It is very common in the US that one party goes in one room, the other goes in the other, and there is no joint meeting. The mediator goes between the 2 rooms, what is often called in the trade shuttle diplomacy. And in the EU, as I say, there is a blend of this. I think in the UK on Zoom, there is an even greater propensity for parties not to meet at all. So we are becoming more and more that the mediator will facilitate. In Singapore, there is the Centre for Dispute Resolution, which is becoming very important, also because the reference to Singapore by virtue of the Singapore Convention that I'll come on to mention is highlighting this process in Singapore. There they also propose a process called Med-Arb, which is a blend of mediation and arbitration, and fundamentally means if a party goes to a mediation, they agree from the outset that if you don't come to a solution at the mediation, that it will immediately turn into an arbitration, and there will then be an arbitration that follows. That's quite controversial from the perspective of a number of issues, including confidentiality and process, and possibly human rights that if there's time we can discuss, but that's something to look out for. And then we also have online dispute resolution. As I say, things are taking off with that. I think that even when we can work in person completely, that all the development we've had in remote mediation using platforms such as these will continue. The word in the mediation environment that I work in the UK and internationally is people are saying this is here to stay for a number of reasons, chiefly time, money, but also perhaps that people feel a little bit more relaxed when they're joining a Zoom call rather than going to a meeting room where, even if it's been agreed the parties won't meet, there is always a risk that they will bump into each other in the corridors. So people may feel more comfortable. So what's happening internationally? As I've said, the international field is very much my area. We have some international law developments. Some of them are now of less interest from the UK, but because I'm speaking to you in Italy, I'm keeping them here for you because, of course, following Brexit, some of the European laws no longer apply in the UK. But we do have a really important first Mediation Directive, 2008, now fully implemented through the EU. And what's important about that is it says that a settlement agreement entered into as a result of a mediation can be enforced throughout the EU. So this is really important because previously many people would say, okay, mediation, isn't it a bit wishy-washy, a bit light, because the outcome is only a contract. It is a settlement agreement, which is a contract. Now, however, since 2008, the European directive said a settlement agreement entered into in one country, if it relates to matters in the EU, there are some technical points within that, it can be recognised and enforced in the other countries of the EU. But as I say, the UK has now dropped out of that. But there's hope on the horizon. I will tell you more about an international convention. And then there was the second mediation directive, which dealt largely with consumers. There's a whole piece around consumers who are unfairly treated in estate agents, travel industry, a number of others, that there should be a very quick method for online dispute resolution. And so some industry bodies have had to embrace mediation to allow that as a way of resolving, well, really consumer complaints. So what's happening now internationally? And this I think is really exciting. I mentioned Singapore as being an upcoming jurisdiction for mediation, partly now because the UN Singapore Convention on Mediation 2019, a really important convention in its idea and its concept, which basically said, if a settlement agreement is entered into in one country, then it can be recognized and enforced in another country. A little bit like the Brussels regulation process that we have of court judgments within the EU. Now, I say it's an exciting convention in its content. It's a little less exciting in its implementation so far, because although a record-breaking 53 states signed the Mediation Convention, unfortunately, the EU as a bloc did not sign, and nor did the countries individually of the EU. The thought was that between them, they couldn't decide whether it should be a one tick for the EU or each country should accede. So it isn't implemented in the EU. The UK has not signed, and nor, for example, has Australia. Now, you may be aware that a convention actually only comes into force when it's then being ratified. And this now happened in September last year, when Singapore, Fiji, Qatar, Saudi Arabia, Ecuador and Belarus have now ratified the convention. But I expect you can see that from that list, there are a number of large and important trading countries which have not yet signed up to the convention. But I would say that doesn't mean to say we should ignore it. Let's hope more countries will sign up. But also the way the convention works is it does not work on reciprocity. It works on the basis of, if there is a mediation settlement agreement that affects things happening in countries where the convention applies, then if certain procedural aspects of the agreement are complied with, that settlement agreement could be enforced in those countries. So the bottom line is that from an English or an Italian perspective, it is possible that a mediation today could be subject to the UN Singapore Convention, because if what is going on in the subject matter of the dispute is in one of the countries that has ratified the convention, then it could apply. And I believe it's going to be acceded to by more countries. And many people are saying this is raising the bar internationally and awareness, and just making perhaps mediation to become a more significant game in town than it was before. The very virtue of with the fact we have a UN convention. I'm seeing a few questions on the chat. Do please keep them coming. No question is a silly question. I would love to hear your thoughts and your ideas. Do please. And I know that Silvana is looking forward to moderating any questions that you may have. We have some time for questions after. So let's just have a look at the mediation landscape in the UK. And I put up a foggy winter day. Actually, today is brilliant sunshine. Maybe you can even hear the birds in my garden. But, you know, typically I will admit that the weather in England is not as beautiful as it is with you in Italy. But we say in England that gives us always something to talk about when we begin any communication. And there we are. I'm already talking about the weather here today. So what is happening though with mediation? So it's got an enormously high success rate. 89% of cases in the year previous to the audit that took place had settled. 89%, that is nearly 90%, really, really high. Now, not everything happens in a day. Rome was not built in a day. 74% of cases settled on the day, but interestingly, a further 15% settled soon after. So what does that mean? That means if people go to a mediation and after the 8 hours, or perhaps an extension of the mediation by a few hours, there is still not a settlement, it is possible for the mediator to propose that the mediation remains open for maybe 48 hours, maybe 1 week. And during that time, the parties will continue to negotiate and also to reflect, maybe to take some advice, some legal advice, some tax advice. And the mediator may well remain involved in this process and continue their job as the mediator by telephone or by Zoom, or occasionally by a follow-up meeting. So I always say to my parties, if there is a case where it doesn't settle on the day, why don't you leave your last offers on the table for up to a certain time, and then let us see if with time and reflection the matter can settle. And if you're interested in looking up more about mediation, the footnote there, the mediation audit by CEDA is something that is worth looking at, because it tells you more about the mediation business and what is happening in mediation generally in the UK. So an important point to mention, Silvana mentioned the human rights and Article 6. The sort of backdoor way that actually in England, although we don't have mandatory mediation at all, there is a sort of a push for people to mediate, because if they do not, or they unreasonably refuse to mediate, then a court may later say, you do not get your costs back, your legal costs back, even though you have gone to court, and usually the winner would recover maybe 70% of their costs back from the other side. Now we have a lot of case law that says, if you just refuse to go to mediation and you've insisted and gone to court, you will not get those costs back, because you've effectively wasted time if you win, whether you are the claimant or the defendant. Now, there's a whole lot of case law on, you know, what is an unreasonable refusal, but the courts have actually said that a reason to give to say, I'm not going to mediation because I don't think there is any prospect of settlement, that is not a reasonable excuse. So the courts have indirectly said every case is capable of settling. So what could be a reasonable refusal? It's too early, the case is not yet developed. As Silvana alluded to that aspect of do the parties really understand the strength and what the issues are of the case? If it's very, very early, that's possible. Maybe the unavailability of one of the people, but they are very narrow and limited reasons. So effectively, anyone who refuses to mediate is taking on a greater financial risk now, because in England, because they may not get their legal costs back. And in my experience, if a case is for a dispute of £100,000 or less, the legal costs can often be more by the time the parties get to trial and have had the trial than the amount in dispute itself. So that's a key thing for people that focuses their minds. So what is the typical process? I've mentioned the frequency with which parties don't meet at mediations. I've got up here that you can have a joint open session. That is more common in person mediations where people are meeting face to face. And the idea is you have a slightly more formal early meeting where each party has an opportunity to speak for up to maybe 10 minutes uninterrupted, to say it how they see it. And then the other party has the opportunity to speak for 10 minutes. And then after that, there may be some communication and some exchange. The difficulty with that is that when people come to a mediation, you're encouraging them to seek peace, not war. This is away from court, away from litigation. We're looking for a deal. And one of the difficulties is that if people come into a joint open session in a very strong and litigious way, this can set a scene which is not so conducive to amicable negotiation settlement discussions going forward. In any case, you have what are called caucuses, just so that you're learning the language of mediation in English. So the caucuses are separate meetings. So usually it would be one party with their lawyer, could be a barrister as well. Remember, in England, we have solicitors and barristers. Quite often I will have both of those with the party in one room. And a caucus is a private caucus where I go to see one party and then the other caucus with the other party. But occasionally I may put together, for example, the two parties, if the lawyers would agree to this. And this can be very powerful. Sometimes just getting the two decision makers sitting on a one-to-one meeting with me present can facilitate an outcome of a solution. In my experience, the sessions, I will go to one room, I may speak for half an hour with one. They will talk to me more than I will talk to them. They will be speaking a lot, telling me what they are looking at achieving. And the meetings may become shorter and shorter. Certainly by the time we get down to the last negotiation of perhaps some monetary amount, in my experience, I can almost be running from one room to the other. Hardly got the time to sit down because literally I am at this point finalizing the monetary amount. Silvana mentioned when to mediate, and she mentioned that those countering mediation and ADR say there is a need for a spotlight, I think she said, to be placed on disputes, and that it should be subject to scrutiny and what is fair and what is right. That is what the those who counter alternative dispute resolution methods say. I would say if a company wants a precedent, they want a court decision about how a certain clause is interpreted, and that clause is, let us say, in their standard agreement that they have with thousands of companies, then that could be a reason to go to court and not to mediate. But other than that, I think most cases are capable of mediation. A question is, how early on in the process do you do it? If you begin a mediation before any proceedings have been commenced, then the defendant may say, I don't know really what the case is against me. I cannot assess my risk. But on the other hand, you have the benefit that people have not invested a whole lot of time and money and got quite a bad case of litigation-itis, as I might call it, the disease of wanting to go all the way through to court, because the longer time goes on, the more people will become invested and think that they are right. So there is an argument for an early mediation But I have also had many mediations that have been very close to trial that have also been successful, because even the cost of going to trial, and for many people, the feeling to go in the witness box and to be cross-examined, because in England, of course, we have a very oral approach to our court proceedings. People will spend a long time being orally, verbally cross-examined and examined. That, as it approaches, can make people feel, actually, I would rather get behind closed doors and agree this confidentiality and also the publicity as well, because court proceedings are, of course, generally public unless the court orders otherwise, whereas the mediation, as I've said, is confidential. So what do we need to do if we're thinking about going to a mediation? I would say we need to put on a new pair of 3D glasses, because we need to look at the dispute from a very different perspective. And what we're looking at is to find a deal. We're looking to find peace. We are not looking to go to court and to win and to be told that we are right. So it is a totally different outset, and the parties should come with an open mind. So there's lots that could be said by this. There's a whole book written about why conflict arises, but it's something to think about. You know, why have the parties actually got into this dispute in the first place? Let's just step back for a moment and to analyze, is it because there's different data between them? They have different data that each of them have recorded. Is it structural? Is one party much more overbearing and stronger than the other? Is it a relationship issue? Do they have different values in terms of their values, either corporate or individual, or do they have different interests? But this is something a mediator will be interested to explore, to seek to find out. And of course, in a court, this investigation has no place, because in a court, the court is looking to find a redress and to give one party some kind of solution. Whereas here we're looking at, why did the conflict arise? And that will then lead us to think about, how can it be resolved in a manner that is satisfactory to everyone? And that's important. The deal just needs to be good enough. It needs to be satisfactory. Nobody is going to get their best day, but equally, they're not going to get their worst day. Whereas in court, one party will get their best day, the other will get their worst day, most likely. So the mediator looks to identify the causes of conflict. How do they do that? I mean, what do I do when I arrive at a mediation? I've never met these people before, and I need to get to help them to find a solution. So the first thing I will try to do is to understand what's happened, but I'm not asking people to focus too much on the past, because the whole thing in a mediation is to get people to look forward and to think about the future. But in order to do that, just like a good history lesson, we do need to have a moment of reflection on what has happened. And it can be important to say to people that perhaps the situation has arisen because of the synergy between the two organizations, rather than it is an individual's fault or there is any blame. It could just be that this has happened because of a change in law, or a ship sinking, whatever it may be. It's not that person's fault, it's what's happened. And helping people to see why others have behaved as they have can be very useful as well, because sometimes it may be that people will agree to disagree. I see what you're saying, I don't agree, we're never going to agree, but it is in everyone's interest that we move on from this and we don't spend so much time going to court. It is better for everyone. So seeing where the other people are coming from can help people to resolve their disputes. And where are people coming from? I've put up this picture just to give you a flavour, oops, it's gone, of why it's important. This picture, if you haven't seen it before, some people may see an old lady, some people may see a young lady. I can describe in more detail how you can see both, but the old lady has a big chin and she's looking down, and she has a big shawl around her head, around her neck. The young lady is looking away and we just see her eyelash. So the point about this picture is it is one picture, but different people see it in different ways. And that is why a conflict can arise, because it is people's perspectives. And that's what in mediation we're trying to unravel. Why do people see things from a different point of view? And can we actually say, look, there is one picture, and at least we can agree on that, and then we can find a solution. And in terms of how do we progress in a mediation, communication is really important. It's important that everybody is clear in their communication, and the mediator will help with this. And one of the most astonishing things that I learned early on when I trained to be a mediator is that words are a tiny fraction of how we communicate. Our voice and our words together is still less than half the communication. Most of our communication is by body language. And of course, that changes from one country to another and culturally. But body language is a really important aspect, and therefore how a person says something, what their tone is, can help the other to understand and help the mediator to find a way forward. So it's not only words, but it's also observing people and observing in one room and observing in the other. So if someone is coming to a mediation, whether as a disputing party or a lawyer, they should have confidence, be positive, coming with an open mind. Now, most people in my experience, if they are in an argument, they are not feeling like this. So it's important that people realize that mediation is a completely different experience to going to court. It is about trying to trust in the process, and also for a moment just stopping to think about where the other party is coming from, because if they do, they are more likely to find a solution that will work for the other party. Now, as I say, most people, if they're going to litigation, are nowhere near any of the points that I have on this slide. So it's like stepping away from the litigation or arbitration process for a moment, if that is pending, and getting into a different mindset for that day of mediation. So listening carefully, re-examining what it is that you are actually putting forward. There are many biases that can be operating in people psychologically as they are in a dispute. And often, you know, we will only see what we want to see, the words of the song, and disregard the rest, the Simon and Garfunkel song. It's important to look again with fresh eyes to think, actually, could this be looked at from a different perspective, just like that picture that I showed? And could it be, if we went to court, that the judge would look at it from that other perspective? And if that's a risk, then maybe we don't want to take that risk, and maybe it would be better to settle here today. So that's something else the mediator will do. We'll do a risk analysis with each party of probability of success, cost of going to court, and then comparing on a really quite financial basis. Is it actually worth it? Is it worth going to court? Or are we actually better financially saying enough is enough? Because if we continue to court, actually, the only people who are really going to benefit are going to be the lawyers. And I say that in the nicest possible way because I'm a lawyer. I'm married to a lawyer. But often at a certain point, any money spent beyond a certain amount is not going to be recovered, as I say, because of the loss of costs in the court procedure and not recovering them later. So, you know, these are the things on the slide that we have to sort of forget about, you know, losing or winning. It is about looking for a deal. So if we were all together, I would, oops, my slides are jumping, sorry. I would be asking you and inviting you to do this exercise. Maybe you can do it with someone afterwards. Basically, you say to each other this sentence: the fox jumped over the hedge. You can say it in Italian if you prefer. And then each time the person says it back to the other, they add in another word. So the brown fox jumped over the hedge. And so it goes on. And you have to keep repeating it back and remembering what the last person said between the two of you. And when you can't remember it properly, you've lost the game. And the idea of this is to show how hard it is to listen and take on board carefully what someone is saying when they are speaking verbally. And that's what's happening with mediation. And I'm very conscious that I've been on this call for some time. I'll probably just speak for about another 10 minutes, and then I really want to look at the questions that I'm seeing coming up on the chat. So do please put anything else that you would like. But the purpose of this exercise is to remind people that when you speak, and if you're speaking about something important and technical and legal, like you would do at a mediation, to speak slowly and to speak in clear terms, using short sentences and quite simple words if you possibly can. And the payoff of all of this good communication is that people are more likely to be honest and to be saying what they really want, what's really driving them. I've had mediations where a contentious probate, where someone, a parent left certain things to their children, their adult children, but one child had the one share in the company. And because they then had one share in the company that the other person had inherited the 99 shares, and these two children did not get along, that was a difficulty. And no court of the land could order for that one share to be transferred to the other. But by talking about this in a mediation, some apologies of things that people have done in the past between these siblings, and believe you me, in contentious probate situations, people do a little relive their sibling arguments. Later, then, it was possible for the party with the one share to say, honestly, I don't want to be involved in this company, but to me, they said, you know, it's quite nice that I can have a little bit of control and I can still be a little bit bothersome and troublesome. So I spoke to them and said, do you really want to be bothersome and troublesome for the rest of your days? Would it not be better to just have clarity and transfer that share to your brother or sister, in return for which maybe something that you really wanted to receive that you haven't received? And that was the way that then a suitable solution was found. And as I say, that solution would never have been possible in court. So there we are. That's why, one of the reasons why I think it is one of the best games in town as a mediator. So what techniques will the mediator use to get people to come to an agreement? Mutualizing, saying, do you know what? The other party are as fed up about this as you are. Obviously, if authorized to do so. Acknowledging how people feel. Sometimes people want to have a day in court, and actually telling an independent mediator is the closest thing they can get to going and telling a judge. Normalizing, saying, yeah, it's a common reaction that you have to whatever the dispute is. Reframing, saying things in different ways, challenging how someone says this, and asking open questions. An open question is a question to which there is never a yes or a no answer. So if I say, are you enjoying this lecture? I might get a yes or a no. If I were to say, how's this lecture going? I will hear a whole lot more from all of you. So a little exercise there would be to try and talk to somebody and only ask them open questions and just see how you find that experience and how they find it. It may not seem too natural to start with, but it's a useful technique to have a go at. So how to prepare for a mediation if someone's going to a mediation? What to do? Preparing realistic settlement options. You know, let's get our facts straight. Let's get our law in place. Let's have a statement which we will share with the other party that isn't a particularly legal one. It's recounting briefly what's happened, what are the negotiation offers made already, and how are the parties seeing the situation. Thinking about what the other party wants to get out of the mediation, and then thinking about some plans B and maybe C, D, and E in terms of risk, costs, and time. So we do have quite a lot of the psychology of conflict going on in mediation. People like to feel they're right. They want to feel that they're important. They want to go to court, as I say, and to be told this and to win. And linked to this is the fact that you have lawyers who are processed, particularly in the UK, but I believe in Italy and also through the EU, if you want to become a litigation lawyer, you want to be someone involved in disputes, you are trained to fight, because that's what a client is coming to see you to do. They want you to get their case and go and win. And so a lawyer who is also willing to engage in mediation needs to take off that hat of being someone who is engaged in a fight, and on the other hand, putting on a hat of more conciliation and looking for a deal. And this is where the parties may get a more blended outcome, and they are more likely to be satisfied with the outcome, because actually the statistics show that people who go to court and win, many are not satisfied with the outcome. Why? Because it's taken them so much time and money to get there. As Silvana has mentioned, costs can be very high, and it can take a long time to get to court. At the moment in the UK, it will take at least a year to get to court. I think in Italy, the delay may even be quite a bit longer. So how do you get people to agree something? And maybe, you know, this is a takeaway for you. Even if you don't want to become a mediator, you want to get two friends of yours to sort something out together. Well, there are three things. The parties need to have their logical needs met. So logically, the deal needs to make sense, but also the emotional needs. And that's where the apology or the being heard comes in. And then there's the third thing, particularly if people are negotiating about a financial dispute, where's the bottom line? Can I push more? If I pushed even more, would I get better? Sometimes people will say to me after the mediation, do you think I could have done better, Rebecca? It's too late to go into that. So I usually will say, if the deal is good enough for you, then that is okay. You know, is the deal good enough? That's what people are looking for. Something that they can live with is sometimes what I would say. So could you be interested in becoming a mediator? Well, I hope that I've excited some enthusiasm in some of you. You may like to know more. Basically, it's a national qualification. So each country has its own approach, but most jurisdictions, you don't actually need to be legally qualified. I believe in Italy, there may be some criteria relating to some legal qualifications. We can always discuss this more with others. Going to watch a mediation can be a great way to get an idea of what it's like. There are even some mock mediations that you can watch online. If you Google in YouTube, you might be able to pick up a mock mediation of maybe an hour and a half. Maybe it would beat an hour and a half on Netflix one evening just to watch a mediation. The thing about becoming a mediator, though, is it does take time to build up a career. So don't give up what you are otherwise doing. But many lawyers are lawyers as well as mediators. So that's a little summary of what is mediation. I hope that's given you a flavour of what it is like to be a mediator, what it is like to go to a mediation. Where does mediation sit in the spectrum of ADR? The fact that, yes, it is there following on from negotiation. It's interesting to consider at what point it may be used in relation to an arbitration or a litigation. What's happening internationally? Of course, I would love to hear more of the perspective in Italy and other countries, but how are trends developing? A little bit about a typical process. I hope it's given you an idea. Such a different process to going to court or an arbitration. And then I hope it's given you a flavour of mediation skills which mediators use, which, as I say, if nothing else, I believe are really important as life skills. And actually the mediation skills are at the cornerstone of the United Nations and the negotiations that happen at the UN internationally. And that's what brings me to my conclusion, which is I am always looking for peace through world trade. That is a motto of the Worshipful Company of World Traders that I'm a member of. It's a livery company. You can actually see behind me there my little certificate that shows I became a member of the City of London. And the Worshipful Company of World Traders says if people can trade peacefully, that could be the start of peace globally. And I believe that mediation has a very important part to play in resolving disputes globally. And I would hope, I am a great optimist, but I would hope that through that, perhaps mediators could play a small role in developing peace globally. So thank you so much for all of your kind attention. Thank you very much for inviting me. It's an absolute honor to be here with you all today. And I pass the word now to Silvana to see if there are some questions and topics to discuss.
Rebecca, thank you so much for your brilliant lecture. It was so interesting that during your lecture, I collected some questions and comments, and now maybe we can go through these questions and comments because they show the interest of the participants in mediation and what you have just said and explained so well. So actually the first question is for me because it's about Italy, and the question is, has Italy's mandatory information session for civil and commercial claims succeed in reducing the backlog of court cases? Well, this is a very good question, and actually my answer is yes, it has been successful. For example, the Doing Business report, that is a report done by the World Bank, said that mandatory information sessions for civil and commercial claims in Italy had a positive impact on reducing the backlog of court cases, well, especially when the conflicting parties decided to appear at the mediation table. Of course, if both party appears, sit at the mediation table, then the success rate increases. But it is true, in Italy, there is still some lawyers are reluctant to embark on mediation, and so we should work on this point, and we should try to change, especially through educational and training programs, this traditionally view of justice, this court-centered view of justice. But I think the culture is changing, and through these educational and training programs, especially now at the university, we can say that lawyers are now are less reluctant to advise clients to use mediation to solve their dispute. And statistics show that the backlog of court cases has been reduced through mediation. So we are optimistic. Then there is another question that is for you, Rebecca, is the following. Since with Brexit, the UK will no longer be subject to the EU law, so also directives such Mediation Directive, well, could it possible, in your opinion, that the UK will ratify the Singapore Convention to provide some kind of continuity with regard to rules on mediation? What do you think? Is that feasible? Is not? What do you think? What is your feeling, Rebecca?
So I'm hopeful, and most mediators in the UK are hoping. We very much want it. We are writing a lot. We have our Civil Mediation Council, CMC, which is sort of like our trade organization for mediators. It's not a regulatory body, but it's there representing mediators, and I'm a member of it. And the Civil Mediation Council is writing frequently to the government, pressing upon them to join the Singapore Convention. But you know, right now, the government has so much to do. It is not high priority. I think probably an equally high priority is for the UK to join the Lugano Convention, because if we join the Lugano Convention, then so much that has fallen out for the UK with the Brussels and the Rome regulation would come back. And I'm really excited that 2 days ago, I read that there was a meeting between the UK government and the Lugano representatives to see if there is something happening for that. So I think Lugano is looking more likely. and therefore Singapore may follow. But in the meantime, people are saying Singapore is there, you know, and actually the principles are there. It is possible that it could apply in some situations. It has raised the awareness. It has raised mediation to an international platform. And with regard to the EU Mediation Directive, a very important part of that is there is a code of conduct for mediators. And I personally signed up to that, of course, when we were in the EU, and I still voluntarily admit to that in my practice. And the Civil Mediation Council still invites mediators to say, yes, although we don't have to, we will voluntarily agree to that code of conduct. So, you know, mediators are flexible. We will flex to what the situation is. And so we are in any case continuing, but I really hope that the UK will join the Singapore Convention.
Mm-hmm. Well, I hope so that the European Union will do the same. I think maybe it's more difficult because having the directive on mediation, and part of this directive is about recognition and enforcement of conciliation agreement, mediation agreements. Maybe there are political issues about that, because we should try to combine these two legislative instruments, one international instrument, the other European legislative instrument. So I think this is the issue that we have to face. But certainly from a worldwide perspective, from a cross-border perspective, the Singapore Mediation Convention is really a good tool and can really reinforce the use of mediation worldwide. And maybe we can move forward to the last remark I collected, and then we go back to another question, because one of our participants is very interested in mediation, and she would like to know more about the potential career opportunities for her or for young lawyers or for young professionals. So especially in the international arena. So you have already addressed, Rebecca, this topic from the UK's perspective, but you practice internationally. So maybe you can give some advices to our students to encourage them to start this career. What about that?
Yeah, absolutely. I would be delighted. I'm passionate about mediation, and anybody who wants to join the team of mediators would be great. I train people to become mediators, and I have trained people in France and Germany. So you can get a UK qualification if that's what you want. In the UK, it takes about 40 hours. So it's not a long qualification. You do a little bit 12-hour distance learning, and then it's 40 hours. And at the end, you have a video assessment. The video is recorded of you doing a mediation, and then it is marked, and then hopefully you become a mediator. So then to join the Civil Mediation Council, you should do, I think, 3 observations of mediators in action. And I think at the moment you must do 1 mediation yourself. And then you can begin. And the exciting thing right now is with Zoom, the world is your oyster. You know, you could become a UK accredited mediator and you could begin. Is age a barrier? I would imagine that some of you may be a little younger than I am. I don't think so. I think with the use of technology, it is becoming a younger person's market, because some of the older people are actually not so interested and not so used to using the technology. But you do need to have authority, and you need to have, you are in charge when you're the mediator. So you do need to have some confidence, but that's something that you can develop. You can co-mediate, you can mediate with someone else to develop your practice. And there are a number of areas which I think particularly for younger people, technology disputes, disputes relating to social media, to marketing, to data. Many of these topics are topics which frankly those younger people are closer to living experience of it than older people. So I think it's a great thing to have as an adjunct to also being perhaps a lawyer. And also, if you then have to go to mediations with clients, that's an amazing thing to have on your CV. Some of the people I have trained to be mediators are heads of litigation in a city law firm. They don't actually want to be a mediator, but they want to know how the process works, what's going on with the mediators. So that too is interesting. So I think it is a growing and exciting field. But I don't know, Silvana, if you want to mention how long, I don't know how long it is to become a mediator in Italy. I think it's a little bit longer.
They have to take a course which consists of 50 hours where you have theory and practice, science and art, and then you have there you have some mock mediations in order to test your practical skills. But at the moment we have a commission, a legislative commission, which is working on the current legislative act on mediation. And now we will see if something is changing, because we would like to reinforce and to enhance, to promote mediation training, because especially the practical part is very important. And maybe under the current legislation is not really it's not really stressed how important it is to have this practical part, this practice. So we are looking forward to seeing what this reform commission will deliver, and so maybe something is going to change, will change. But actually at the moment there are 50-hour courses to be accredited as a mediator, as a professional mediator. I think we can end this very insightful lecture with a very challenging comment from one of the participants. Can we say that with mediation we are coming back to a more natural form of justice? I think it's very nice comment to conclude this lecture. Can mediation become an important alternative to international tribunals whose jurisdiction is often not perceived as legitimate, and maybe even become the main form of dispute resolution in the future? I think it's a really illuminating and a brilliant comment, an optimistic comment. So maybe we can conclude adding some commentary on this nice statement. What do you think, Rebecca? Could be a natural form of justice?
Absolutely. I think that is a really, really good comment, and very well written. And I love how it's written. And the way that word, is it a more natural form of justice, encompasses so many things about mediation, that the process itself is natural. It has that natural and sort of comforting approach. And actually mediation began, I mean, I said it began in Australia, but some people say it actually began back in China with the elders resolving disputes, and in African tribes. And this is, so we can say that those of us studying, I haven't studied in detail, but anthropology, that actually mediation is in the DNA of humans, and that is how we are made to resolve our disputes rather than asking someone else to. So yes, I'm very impressed by that comment. Thank you so much.
I think it is one of the best concluding remarks that we could have, because as supporters of ADR, this is a very good view of our horizons, of our future. So unfortunately, the time is already over, and your very, very good lecture was very inspiring. So I hope all participants enjoyed your insightful lecture. And I thank you again, Rebecca, and I hope you will be with us soon. Thank you very much. And thank you all participants to have participated in this webinar. Thank you.
Thank you. The pleasure was all mine. And thank you for the very kind invitation. Thank you.